Hi, my name is Akiva Goldman. I'm the director and founder of Goldman and Associates, and today I want to talk to you about court dates. A lot of clients are under the impression, particularly in family law cases, that when they have their first court date, that means by then everything will be resolved. All their problems will be solved. I have to tell you that it's not necessarily true, that there are some dates that are essentially placeholder dates. Lawyers call them different things. They call them trial dates, they call them control dates, they call them dates by which the court wants to know what's going on. The court may fashion it as a trial date and call it a trial date, and your lawyer may say, we have a trial date on September 24th. But if you think that necessarily means that by September 25th, everything will be resolved, you are mistaken. That is not how it works. Those dates are typically soft dates unless your lawyer tells you otherwise. Those are dates by which the court gets an assessment of where you're at on the file. Many times those dates are adjourned for other dates. It's not adjourned because your lawyer screwed something up. It's not adjourned because the other side is playing games. It may be adjourned because the court has 30 cases up for trial on that day, and yours is the youngest, and they're taking the older ones first. It could be adjourned for a lot of reasons. I once had a case adjourned because the judge told me he got a call right before trial. Turns out his girlfriend locked herself in his garage. He had to run home to set her free. I mean, things happen. We didn't tell anybody about that, but that's what happened. And it's always a joke. Every time I see that judge, I ask him, did you give your girlfriend a remote? He knows what I'm talking about. But the point is that there's a lot of reasons why a case gets scheduled or doesn't get scheduled. And you cannot expect that all issues in your case will be resolved because you've got a trial date coming up. You have to talk to your lawyer and find out, is that a hard date or a soft date? What does that date truly mean? If your lawyer says, you know what, we filed a request for some information, we sent out some subpoenas, the information hasn't been produced yet, we're going to adjourn that trial date because we want all the information available. That doesn't mean that your lawyer is purposely delaying this so you will have a higher bill. That's not what it means. It means that the case has to be prepared. And you know how long it's going to take? It's going to take as long as it takes to do a good job. And if that means it's going to go quicker, it'll go quicker. And if that means it's going to go slower, then you know what? It's going to go a little slower. And you're just going to have to rely on the people that you've hired, the people who have the reputation who do this for a living, and you're going to have to rely that they know what they're doing. The best thing that you can do is cooperate with your lawyer. Give your lawyer, information that they need. Don't wait till the last minute to furnish valuable documents that your lawyer's been requesting, because that in and of itself can also cause a delay. So a lot of times what you have to understand is that dates mean certain things to the court, they mean certain things to the lawyers, and they mean certain things to the client. And what you need to understand is what they mean to you may not mean the same as what they mean to the court. So you got to have an understanding with your lawyer about what's the relevance of those dates? What do they mean? A lot of times when you have cases, there'll be unraveling that has to be done. Perhaps there was, for example, an estate. The estate is closed. It has to be reopened. In order to do that, filings have to be done. And it delays a different part of the case because of this part of the case. These things can go on. And the amount of examples that I could bring, just hundreds and hundreds of different types of permutations, thousands, that go into this. Every case is different, but you have to understand the importance of the fact that it is a process, it will work, but it won't work immediately. And winning a motion or losing a motion doesn't mean that you were right or wrong. It may mean that the court at this time wants to see a certain result. It may change its mind. It may make a temporary decision with the understanding that a permanent decision will come later on down the road. This is very important for clients to understand. I think if you understand these things, you'll have a modified expectation that's more consistent with how the court works. I think when clients get frustrated, it's because they just don't know what goes on behind the scenes. They just don't understand that the court feels their case is important, but as important as it is, it's got a lineup of cases that are important. And so it's going to take them in the order in which they were received. And your case might have gotten beat out by someone. And you know what? The court is only handling so many motions that day, so you get pushed off to the next week. You know what the problem is? Next week there's a judicial conference. The court isn't there. So now you're 2 weeks away. Who are you going to blame that on? And the answer is, don't blame it on anybody. Don't engage in the blame game. Just do what needs to be done, and your lawyer will do likewise. And you know what? You will have a good result, and it's going to work out fine. But trust the people who live in the system, who are day in, day out in the system, to guide you in terms of what makes sense, what doesn't, what's a normal delay, what's an irregular delay, and your lawyer will tell you. And then I think you'll have a better understanding and a more reasonable expectation about how these things are going to go.